judgment in the matter of A and 6 others against C and 13 others.
This appeal from the Court of Appeal of Bermuda is about the role of someone called the protector in the administration of a trust. A protector is a person, or sometimes a company, upon whom the person setting up the trust, usually called the settlor, typically confers limited but important powers which operate alongside the much more extensive powers of the trustees, both in the management of the trust property and, more importantly, in discretionary decision-making about which beneficiaries should receive it or its income, and in what shares, by the exercise of what are called powers of appointment. Typically, protectors are appointed in offshore family discretionary trusts, that is, where the beneficiary family is mainly based in the UK, but the professional trust corporation is based offshore. They are seen as serving as a sort of communications bridge between the family and the offshore trustee, the directors of which may have no previous connection with the family, whereas in a purely domestic trust, the trustees themselves are more likely to include persons who know the family well. Protectors may be given any powers which the settlor chooses to confer upon them, but typically they include powers of veto over proposed decisions of the trustees, mainly as to which of the beneficiaries should receive the trust property. A trust deed will have to specify precisely which types of trustee decision are to fall within the protector's power of veto, but it is usually silent about just how the protector should go about deciding whether to approve or to veto a trustee proposal. There is a quite long-standing debate among judges, academics, textbook writers, and trust practitioners about what the protector's role should be where the trust deed is silent about it. Two main contenders have emerged. The first, called the narrow role, is that the protector's task is limited to reviewing the legality of the trustee's proposal. Is the trustee acting within its powers? Has the subject matter of the decision been properly researched by the trustee? Has the trustee taken all relevant matters into account and excluded irrelevant matters? In the case of a proposed appointment, has the trustee properly considered the claims of each member of a class of discretionary beneficiaries to share in the trust property? If the protector answers all those questions in the affirmative, they must, under the narrow role, consent to the proposal, even if, left to themselves, they would have made a different decision among what may be a range of perfectly lawful and available alternatives. The second, called the wider role, is that the protector is empowered to form his or her own view of the merits of the trustee's proposal. If the protector disagrees with the trustee's view of the merits, then they may veto the proposal, even if it is one within a range of decisions which the trustee may lawfully make. Everyone agrees that in principle it is for the settlor to choose either of those roles for the protector, or indeed any other role. So the question what role the protector is to perform is a matter depending upon the intention of the settlor as ascertained from the words of the trust deed. In other words, it's a question of interpretation. But what, the parties ask, should be the default role if the trust deed, as it very often is silent about the role of the protector? The present case concerns a large number of discretionary trusts for the benefit of members of the same family, each with identically worded provisions for one or more protectors, giving them power of veto over the trustee's proposed appointments of the trust capital and a power of veto over certain investment and property management decisions, but being silent about the protector's role. In 2017, the trustees produced proposals for the allocation of the aggregate property of all the trusts between the settlor's two children and their respective families. Aspect of the proposals required the protector's consent. The two branches of the family took opposing positions about whether the protectors were required to perform the narrow role or the wider role. The need to preserve the anonymity of some of the family's children as beneficiaries, coupled with the risk of the proceedings affecting the market value of shares in a large public company in which the trusts have a large shareholding, has meant that the proceedings leading to this appeal have been heard in private in Bermuda, both at first instance and in the Court of Appeal, or the suitably anonymised judgments have been handed down in public. Most exceptionally, the same course has been adopted in this court at the request of the parties. The hearing was in private, but this judgment is, again, being handed down in public. Both the first instance judge in Bermuda and the Court of Appeal unanimously concluded that these trustees conferred the narrow role upon their protectors. In bare outline, they considered that the normal or default role of a protector was merely ancillary to the primary decision-making role of the trustees, that to give the protector the wider role would be to confer joint decision-making between the trustees and the protectors, and that this would, in the event of their disagreement, as has occurred in this case, be a recipe for deadlock, delay, and additional cost. This court unanimously disagrees with the courts below. Lord Richards and I give the opinion of the board, with which Lord Reid, Lord Stevens, and Lady Rose agree. In the board's judgment, these trusts confer in substance the wider role upon their protectors. Our reasons are in summary as follows. 1. The common understanding that the role of the protector is a matter for the settlor to prescribe in the trust deed is correct. The question what role has been prescribed in any particular case is therefore a matter of interpretation of the trust deed. 2. There is no single default role implied by law wherever a person named as a protector is given a power of veto in a trust deed which is silent as to his role. The word protector carries with it no restriction as to the role, nor does it refer to an office with invariable or even typical legal characteristics. 3. Nor is it to be assumed that the interpretative search is for a binary choice by the settlor between just the narrow role or the wider role. In principle, and this applies but is not limited to trust deeds, where a document gives to one person a power of veto or power to veto a proposed action by another, the starting point is that the recipient of the power is under no constraint, apart perhaps from a requirement of good faith, as to how that power of veto is to be exercised. If any further constraint is to be identified, it must be derived from some provision to that effect in the document conferring the power of veto, express or implied. 5. In the present case, it is common ground that the protector's powers were fiduciary. Therefore, the protector was to abide by the equitable obligations of a fiduciary, not to profit from the exercise of the power, not to permit a conflict of interest to affect its exercise, and only to exercise the power for proper purposes. 6. But otherwise, the silence as to the protector's role in the trust deeds means that no further constraints were imposed, nor could they be implied in fact, since they would not be necessary to give the trust business efficacy, nor obvious to an officious bystander. 7. Those fiduciary constraints come nowhere near imposing the narrow role, but they are fully consistent with the wider role. 8. The wider context in which protectors are generally appointed, and the present case is no exception, is supportive of the wider role. It is hard to understand why a settlor should think it necessary to appoint a protector just to ensure lawful conduct by a professional trust corporation, which would be expected to take and comply with its own legal advice. And it would be surprising to see a protector other than a lawyer appointed to perform the narrow role. For those reasons, the board humbly advises His Majesty that this appeal be allowed. The court is now adjourned.